Since the global economy is closely interconnected, when a war breaks out in the Middle East, many countries, including South Korea, often experience simultaneous impacts on their prices. In particular, if military tensions between Iran and Israel escalate, international oil prices, exchange rates, raw material prices, and maritime logistics costs may fluctuate sharply, potentially causing shocks to the entire global economy. When such situations arise, many people naturally begin to have questions like the following. If the cost of living has skyrocketed due to war, can we claim damages from the national leaders who decided on the war? For example, Israeli Prime Minister Benjamin Netanyahu or US President Donald Trump. If it is determined that the military decisions of national leaders like these have impacted the international economy, there may be growing interest in whether global citizens can hold them legally accountable. However, when examining international law and the practical legal framework, it becomes clear that such claims for damages are a very complex issue that is entirely different from general civil lawsuits. First of all, for a claim for damages to be established, several basic conditions must be met. In a typical civil lawsuit, there must be an act of harm. That act must be unlawful, actual damage must have occurred, and it must be proven that the damage resulted from that act. For example, in the case of a traffic accident, the relationship between the offending vehicle and the victim is relatively clear. However, international wars are completely different. When a war breaks out, numerous economic factors such as rising international oil prices, currency fluctuations, supply chain disruptions, skyrocketing raw material prices, maritime transport issues, and interest rate hikes come into play simultaneously. Therefore, it is very difficult to hold a specific national leader legally accountable based solely on the claim that prices have risen due to war. One of the biggest barriers, in particular, is the principle of sovereign immunity under international law. Sovereign immunity is the principle under international law that a court in one country cannot easily try the government or head of state of another country. In simple terms, even if a Korean citizen files a lawsuit for damages against the President of the United States or the Prime Minister of Israel in a Korean court, it is highly likely that the court will determine it has no jurisdiction. Current heads of state or government are strongly recognized for their diplomatic immunity, making it quite difficult for ordinary individuals to hold them accountable through civil lawsuits. So, what legal procedures are actually possible? The first thing to consider is how to file a civil lawsuit in the domestic courts of each country. For example, an individual or a business may claim damages for losses such as increased fuel costs, business losses, investment losses, and increased living expenses due to an international war. In this case, they would submit a complaint according to the general civil lawsuit procedure, organize evidence of damages, and attempt to prove the causal relationship between the war and the damages. However, realistically, there is a high possibility that the case itself will be dismissed at the initial stage, due to issues of state immunity or jurisdiction. The second method is to raise the issue through the International Criminal Court (ICC). The International Criminal Court is an international organization that deals with war crimes, genocide, and crimes against humanity. However, the ICC is not an institution that judges solely based on economic damage. In other words, the likelihood of a case being accepted is low if it only involves simple price increases or living difficulties. Serious crimes such as civilian massacres or violations of international humanitarian law must be proven for a full investigation to proceed. The third is the dispute resolution process between states through the International Court of Justice (ICJ). However, the ICJ is not an institution where individuals can file lawsuits directly. It deals with disputes between states. Therefore, a specific national government must officially raise the issue for a case to be established. For example, while a country can claim that its citizens suffered economic damage due to the military actions of another country and pursue international litigation, the likelihood of actually proceeding with it is low when considering real politics and diplomatic relations. Another important issue is proving causality. Because the international economy has a very complex structure, it is difficult to conclude that price increases are solely due to military actions by a specific country. For example, the rise in oil prices is influenced by factors such as the policies of oil-producing countries, exchange rate changes, international financial markets, speculative capital, transportation costs, and global supply chain issues. Therefore, the court is likely to find it difficult to directly link the decisions of a specific politician to an individual's economic losses. Additionally, war or foreign policy is generally considered a political act. A political act refers to actions that fall within the realm of the state's high-level political judgment, and it is an area where the court is very cautious about direct intervention. In other words, military actions or diplomatic policies are often difficult to judge as simply as general civil issues, and they are frequently resolved in the realm of diplomacy and international politics. Even if a court were to issue a ruling recognizing liability for damages, actual enforcement is another matter. The process of seizing foreign government assets or the assets of national leaders can lead to international diplomatic conflicts. For this reason, it is generally the view of international law experts that it is very difficult for individuals to successfully file a lawsuit for economic damages against world leaders. However, it is possible to exert political pressure through activities of civic organizations or by shaping international public opinion. In fact, protests against war, international petition movements, and investigations into economic damages are consistently taking place around the world. Additionally, companies or investors may pursue realistic legal responses, such as insurance claims or commercial lawsuits for specific losses incurred due to the war. In conclusion, while it is theoretically possible to directly claim damages from a specific national leader due to price increases caused by international wars, it is very difficult to be recognized in practice due to issues such as sovereign immunity under international law, causation problems, diplomatic immunity, and the structure of international politics. It is important to understand that the issue of war responsibility in the international community is very complex, as it goes beyond simple civil lawsuits and is connected to international politics, diplomacy, international law, and the entire economic order.